Rebuttal, sir?
This is the document and all the explanation that came with it was $35,000. So if they were a state agency, apparently every court gets to charge $21,000 or however how many days it was. But that's in there. It doesn't even say what the per day charge is. Court reporter fees, $35,000 for using the building. They don't give you any option to use. The reason they can do that is why the dental board case was cited. Counsel was quite correct. The United States Supreme Court was not litigating the constitutionality of the North Carolina Dental Board. They were litigating whether it was a state agency, a true state agency, entitled to exemption from the Sherman Antitrust Act as true state agencies are. It wasn't concerned, it's North Carolina's business, whether the dental board complies and comports with the Constitution. What I am saying is that the same rationale. Both the dental board and the bar suffer from the same malady. They have no supervision. No one can tell them. If what I listened to the bar saying a while ago is that the same thing that order says. Well, Mr. Sutton could petition to the court and Mr. Sutton could petition to Wake, but if he didn't win, that's his fault, not ours. So it's not our duty to see that he has due process. It is their duty to see that everyone who comes before it receives due process.
What was the outcome of your lawsuit in Wake County? Was it a 12B6 dismissal?
It was dismissed on 12B6 without reason. It just says dismissed due to 12B6, so I don't believe collateral estoppel could ever be an issue in that. And because I don't know why the court granted it.
Was an appeal perfected?
The appeal was not perfected, but without any factual findings, there can't be any collateral estoppel. And for all I know, he thought that it wasn't ripe for an injunction, so he said, I'm not going to pay any attention to the First Amendment right. He certainly didn't take evidence on it.
Was that the only request for relief? Was it an injunction?
No, there was injunction, declaratory relief as well in the Wake County action. And
But the merits were not reached.
It just didn't reach them.
Well,
Didn't
no.
reach any of it.
Well, you're saying it was a 12B6 order without findings of fact, as is usually the case on a 12B6 order, but that doesn't mean the merits weren't reached. It was a dismissal on the merits.
It wasn't a dismissal on the merits. For all I know, he said a cause of action wasn't properly stated. I don't believe, with all due respect, Your Honor, that's a dismissal on the merits. That may be, as counsel said, a pleading error. He didn't specify why. And counsel said something I want to address before I step down, is that the appellant misapprehends the Constitution. The Constitution of North Carolina is very clear. In one of the cases cited in the brief, I believe it's Dumont, but it could be another one, I'm not 100% sure. It explains how we had the 1970 Constitution. It came from the 1968 Commission, and they reorganized government. And after they did that, in the Constitution, they had Article 3, Section 11, that says every administrative agency has to be allocated. It does say there are some bodies that need not be allocated, but in Article 4 on the judiciary, it says only administrative agencies may have judicial functions. If the bar doesn't want to be allocated, that's fine. But as they say, they're not in the executive branch, and there's no provision for any agency in the state of North Carolina that is not in the administrative branch of government to exercise any judicial power. They say they act from the state of North Carolina, but I defy the bar, and they have it today, said, here's where we are in the Constitution. In closing, I would like to say to the court that I would ask to vacate this. They're without jurisdiction, they act extra-jurisdictionally, they don't have jurisdiction, so there's no point to remand it. When they had the opportunity to make findings and conclusions, they didn't do so. There's not a single word of speech or freedom of First Amendment in a 35-page single-spaced order, and they shouldn't get a chance to do it again. This case does, to a certain extent, hinge on society and civilization because we have that contract, the Constitution. The bar is required to follow it, and we're entitled to receive the benefits of it. In this case, the bar essentially said, it's not our problem that his license is taken, and nobody has yet said how the First Amendment rules or not. Thank you.